Good afternoon, friends. I'm once again back. Sat Sri Akal, Adab, Namaskar. It is in continuation to my earlier videos that if the OGB bungalow, which I said is with the on a situation of 5 parameters, let's say it is on hire, it is in possession with tenants, possession of army, it is in a dilapidated situation, HORs have a dispute, under inheritance, and mutation has not done of the illegal HOR for the last some 50-70 years. What does a bungalow owner do? Let's say today we are talking of a possession in the hands of tenants. Now there are illegal tenants mostly sitting in our servant quarters. There are tenants sitting even in our some outhouses or let's say garages which were earlier. So the rent paid may not be there or may be very meager, 10 rupees or 20 rupees. And astonishingly, there is no agreement between these tenancies. So does the local or the civil area tenant act or the state rent act apply on these? That is a multi-millionaire. Ask your advocates. Does rent act apply to these cantonment boundary pillars? So what do? How do we evict these bungalow owners or these illegal tenants? In some cases, I have seen that yes, semi-portion is in with tenants. Some tenants have made the property in a dilapidated situation. They're not leaving their possession. The roofs have fallen or the walls have crumpled. Yet in their possession, and HOR is also under a dispute within the family. So there are so many issues which get involved in past 30-40 years because the generation changes. So one and the second doesn't get along. Bungalows have been abundant. HORs are not actually physically in the bungalow. So there are so many things. Portion of the bungalow is with the HOR. The other portion mainly is outhouse or the main bungalow is with the tenant. So in these cases, generally we tend to run for eviction. So we say, let's go file a suit. No. Why don't we sit down? Talk to the tenant that I need the bungalow. Let's negotiate with him. Let's make a good handshake with him. And if it doesn't happen, we can even rope in the department that since he's an illegal occupant not recognized by the original HOR, he should be evicted from here. Why give him those basic necessities which the Supreme Court upholds, which is called light, power, electricity, water? Try and make sure that these are all given through you, instead of him having independently applied for with the board and getting those connections in his name. So everything needs to be settled. Everything needs to be brought on table first. Once these files, documents, records of agreements with these tenants is there, then we can think of moving forward. Because lastly and foremostly, that tenant will get up and say, you are not the owner of the grant. It's an old grant, land belongs to government. It's only the built up portion which belongs to you. So where do we land up? We are nowhere. Our courts will finally say, well, you are not the owner. Even if you want the eviction, maybe the department would move an application and say, okay, fine, let's resume the bungalow. I'll share it with you. I have a case of Ambala where the department has said, we will not resume this bungalow because there are too many tenants in this bungalow. So correct pleadings have to be done. Facts have to be brought onto the table. And we need to admit ourselves into one, which I keep saying. Yes, we are old grants. You know? So we will not plead we are owners. We will say we are old grants. So now again the question would rise up here, Mr. Das. Yes, you've told us all this. Now how do we begin? Let's talk. My numbers flowing down the YouTube. Or you can mail me your documents. Let us get into those similar executive correspondence. Let us get into those various orders of the courts which say that yes, an illegal occupant needs to be evicted if the HOR is not willing to have him anymore there. It may take time, but his eviction stands. And this is a better case than if it is on hire with the army. Because here the bungalow, the tenant cannot say that he will not get evicted because of various reasons of the Rent Act, which is not really applicable, but we will file it under that only. we need to pick up our own land records, because if we don't have our own land records, it would be very difficult for us to really claim our rights under the old grant. So all of us need to understand, let's say if there is an agreement between a tenant and the original HOR, maybe your grandfather or your grandmother, so then these agreements have to be brought on table. How we can put him into a shoe where he can be termed as an illegal occupant now. Let's say the lease is expired, not been renewed. So we'll work on these questions. So land records, all your files from the CODOs are very important. Once this is there, we can all get in touch and then we can make our pleadings. But here I must tell you one thing, I'm going to plead in such cases where, let's say, these tenants are very troublesome. And I would prefer if the department or the DEO of your cantonment also falls into this case, and we finally plead, okay, fine, if it's not being dehired, resume the bungalow voluntarily. So there I really need your building plans so that I can even plead, which most of the advocates would say, this is Mr. Das discriminating, and this pleading may not be accepted by the CPC. I'll give you a lot of judgments on this. On one side, we will say we are old grants, and the other side, we would say even if not dehired, let's be compensated after being resumed. So all this. So friends, dig in your records, go see your tax superintendent, get your records from there, get your building plans from the building inspector, and once all this process is there, then we can get this bungalow measured if you're not physically living into this bungalow, or if you're in a part portion of this bungalow, so that we can estimate it through an architect. What is the market value of this? Get your collector records of this bungalow. So all these things would mean a lot of hard work. But stepwise, land records to this, these are two different subjects. That is why I say, first get your Janampatri done. Once that is done, it's very easy for me to move the next step of eviction. So I need to recognize you, even if you're an illegal HOR. Let's say you bought the bungalow in 1970 and you were expecting that it might get dehired, but it didn't happen. So in 2020, you want to get rid of the liability now. So I need to build you up on an HOR. How? So I'll get your tax purpose mutations done. Every step would be needing a lot of effort, because I remember there is a case of an honorable judge where his compensation has not flown in just because the bungalow was changing hands, and during that period, this side and that side, the resumption notices were given. So friends, try and trust it. Get in touch with me. We can all do this in a very handful manner. And I can assure you, in this case, where tenants are there, not by the army, we can get evictions done. Once again I say, we guys are old grant bungalows. Since 1793 till the culmination of 1859 regulations were never converted into new grants. That is why till date our GLR says we are old grants. Thank you. Good day.